Today's NHLBI Small Biz Hangout. Our topic today will be intellectual property for the new biomedical innovator. And our presenter today will be Dr. Gautam Prakash, who is an intellectual property specialist here at the National Heart, Lung, and Blood Institute's Office of Translational Alliances and Coordination. I'm going to be your moderator today. My name is Chris Sasiela, also with NHLBI's Office of Translational Alliances and Coordination, and we certainly hope that you will enjoy today's presentation. This series has been developed by our office to help our community understand some of the key elements in biotechnology development. All of these events are specifically targeting our SBIR, STTR applicants and awardees in the hopes that an increased understanding of some of the topic areas critical for biomedical innovator success, such as regulatory considerations, market space analysis, and intellectual property, will help them be more successful in developing their technologies. However, we understand that these knowledge areas are critical in all areas of both biomedical innovation as well as other spaces, and we certainly hope that you find today's presentation to be very useful. If you're not able to join us live today, these events are archived, and you can certainly go onto NHLBI's YouTube channel and search for Small Biz Hangouts, and you'll see a series of them popping up in these different disciplines. We hope that you do take the opportunity to look through the archived materials, as we find that they're very useful as people are developing their technologies and their commercialization and business strategies. If you have questions throughout today's presentation, you can provide them in a number of ways. You can either post them on Twitter using either the hashtag SBIRchat or direct messaging us through our office account at NHLBI_SBIR, or you can send them to us by email. And our email account is nhlbi_SBIR@mail.nih.gov. We will be checking all these forms of media periodically and stopping throughout Dr. Prakash's presentation in order to address the questions as they come up. Now it's my pleasure to introduce our speaker. Dr. Prakash joined the Office of Translational Alliances and Coordination about 1 year ago with the purpose of helping us to advise our Institute's biomedical innovators and to develop some educational content related to intellectual property definition and protection. His experience includes greater than 15 years working as a patent lawyer advising clients in filing claims and as an examiner at the U.S. Patent and Trademark Office. He received a PhD from the University of Maryland, College Park, and his JD from George Washington University. Today, he will be providing us with an overview of the various intellectual property protection strategies that small businesses might employ and might include in their commercialization plans as they are applying for NIH funding in this space. At this point, I would like to welcome Dr. Prakash and hand the screen over to him. Welcome, Gautam.
Great. Thanks, Chris. Thanks for that wonderful introduction. Before I start, I would like to, unfortunately, have to read let's call it a public service announcement that I'm glad to tell you that this presentation is meant for background educational material only and is not meant to provide legal advice or serve as a substitute for specific legal solutions to your particular intellectual property situation. Well, now that that's out of the way, that was okay. So here's some items I'd like to cover today. First, I'd like to introduce you to the 4 major types of intellectual property rights that you're likely to use, which are patents, trademarks, trade secret, and copyright. And once that's over, we'll quickly look at an introduction of the patent and trademark examination process and the copyright registration process, and we'll discuss some portfolio considerations. Most of us know this already, but it's worth emphasizing that IP rights protect inventive and creative ideas. And as we've just learned, there are 4 basic IP rights. Now, this is here again: patents, trade secrets, trademarks, and copyright. I'm going to use this continuous positive airway pressure mask, or CPAP mask, which is used for treating sleep apnea, to show you how aspects of this device can be protected using utility patents, design patents, trademarks. And just as an aside, the research into and treatment of sleep disorders is one of the missions of the National Heart, Lung, and Blood Institute. Okay, before we go into some specifics, it's at least worth taking a moment to see what a patent is. I'm sure most of you know, but here's the definition. It's rather large and overly complicated, but what you really need to know that a U.S. patent excludes others from making, using, offering for sale, selling, or importing the device covered by invention, by a patent, I'm sorry, invention covered by a patent for a limited time. So it's important to note that it's a negative right, so it excludes, it doesn't allow you to do anything. It allows you to prevent others from doing, covering, importing, using, so on, what you have patented. Okay, what is a utility patent? This is the most common one patent that you may have heard of. So, looking at our CPAP device and utility patents, as the name suggests, a utility patent is granted for a new and useful products and processes. Here we see an example of one of the utility patents that protect the CPAP mask. And the utility patent protects the specific elements of the mask and the manner in which it works. Most of you have heard of patent claims, which are the most important part of utility patent, because the claims delineate the scope of the protection that you're seeking in the utility patent. And in particular, the claims cover what is protected and what isn't protected by the patent. The second most relevant US patent is a design patent, which is also called an industrial design in Europe and some other areas, some other countries. And unlike a utility patent, a design patent covers the way an object looks. So here we can see a design patent for one feature of the CPAP mask, namely the ornamental features of the face mask assembly. I've also seen design patents on ornamental features for the forehead pads of a CPAP mask, breathing tube connector, the overall frame. So you could get design patents on a lot of different ornamental features. A design patent only ever has one claim, and that simply says the ornamental design of the device, as shown here and described. In this case, is a face mask assembly. And if you look at the actual face mask that's been manufactured, you can see how closely it matches the drawing on the design patent, which is really what you want. You want the manufactured device to cover the same features as described in and protected by the corresponding design patent. Okay, so at this point, some of you may be thinking, well, if I can get patent protection for both the way my device, my invention operates, and the way it looks, then why isn't this Hangout over now? Well, one answer is that obtaining patent protection requires disclosing your invention to the public, and in certain cases, you may not want to disclose what your invention is. So, are you out of luck in that situation? The answer is no. Trade secret protection is really what you're looking for in those types of inventions. So, trade secret protection specifically is excellent for inventions that cannot be reverse engineered. The most famous example of which is the formula of Coca-Cola, which may be the world's most closely guarded trade secret. Trade secret protection is far more than just recipes and formula. It can also protect manufacturing processes, and in this increasingly electronic world, it can be used to protect software. So most of you, I think, know that patent protection is finite. and at some point the patent will expire, but not so for trade secret protection. And that actually lasts indefinitely. Of course, you need to protect the secret. Now, Coca-Cola's trade secret has lasted for over 125 years. And trade secret protection can clearly be a robust form of protection of your invention. Okay, so having covered trade secrets, let's move on to something that sounds similar but is actually very different. So trademarks. Here again is a fairly longish explanation of what a trademark is, but at its core, a trademark is a word or symbol that indicates the source of a good, or sometimes services if you're providing a service. So just think, if you see the swoosh on any item, shoes, jackets, bags, hats, no matter what, you know automatically what the source is, which is Nike. So that's what a trademark is. Indicates the source of the goods. So our CPAP example is also protected by trademarks. Here's one. Simplest is shown with this listing from the Patent and Trademark Office registry. And from the trademark listing, you can see that Simplest, you can determine whether a trademark is a word, symbol, or combination, in which case it is a word mark, the word Simplest, how it's written, and what class of goods it is for. In this case, the word mark Simplest is a trademark for a class that covers medical apparatus and instruments, which is what the breathing mask is. Here's another one, Roll Fit. Here's another one, Ergoform. So the CPAP device also has trademarks protecting it. Trade dress. Some of you may have heard this term, and it really is a form of trademark, and the simplest. And the way to illustrate it is, just imagine you're driving through a blinding snowstorm and you saw this building in front of you. If you saw nothing else, no other signs, no other indication, would you know where you were going? And I suspect for most of you, the answer would be yes. And how would you know that? Well, from its distinctive red roof, angled red roof, the shape of the building. So really, trade dress, you can consider it as a visual trademark as opposed to a word or a symbol like Simplest. And it covers the look and feel of a product. And back to the definition of a trademark, indicates the source of the goods. So here, would consumers know what the source of the product is in this case? Sure, everybody would say, yes, I know I'm going to McDonald's. So that's a very strong trade dress for McDonald's. And as I said, it's a form of trademark, so you may be able to register it as a trademark at the United States Patent and Trademark Office. Finally, the last major IP protection is copyright, which protects tangibly expressed works of authorship. And I think some of your audience may be surprised to think of aspects of the CPAP device being protected by copyright, but as you can see, here copyright is being used to protect the contents of the mask's instruction sheet. Right? It's a tangibly expressed work of art, if you want to call that, authorship. And you can also use copyright to protect other things, including websites and, once again, software. Okay, so about a quarter way through, we've gone over some introduction of the four major forms of intellectual property protection, looked briefly at patents, trade secret, trademark and trade dress, and copyright. And at this point, before I move on to the next section, I'll pause for a minute and turn it over to Chris and see if we received any questions.
Thank you very much. So as you'll note, I've still got up the slide that will tell you how to submit questions. I know that we have quite a active audience out there right now. And so we've actually already received one question, Gautam, and that is, who polices patent infringement?
So the patent infringement is policed by the patentee, and so the patent owner, and which comes as a surprise to some people because they think that the United States Patent and Trademark Office is the policer of patents. But that is not true. Unfortunately, the Patent and Trademark Office does not have anything to do with enforcement of or policing your patents. So you, as the patent owner, are responsible for that.
Okay, well, thank you very much. That's the only question that we've received thus far, so back to you.
Oh, great. Thank you. Let's move on. Okay. Great questions. So, okay, patents. We've all heard about patents. We have heard about people saying they need to obtain patents. And at the end of the day, why do I really care? Why do I need patents? Why should I get them? Why does everybody make a big deal about it? And here is a very simple explanation as to why in the biomedical and other areas of invention that you would like to get a patent. You don't have to, but we often think of a patent as the best opportunity for an inventor to benefit from the invention. Once again, they do that by excluding others from making, selling, or using it. So it's a negative right, once again. So how does one get a patent, a US patent? At least in the United States, the first thing you do is you need to file a patent application at the United States Patent and Trademark Office. Next, the United States Patent and Trademark Office, or USPTO, will examine the application, and you have input into this process, you as the applicant. So it's important, and I do like to emphasize that the PTO is a partner in the patent examination process with you. And please do not think of it as an adversary. We both have the same goal, the patent office and the applicant, which is that both entities want to ensure that there are valid and enforceable patents at the end of the process. So you do have input into the examination process. Okay, during the process, the application is found patentable. The patent office issues you a notice of allowance. You then pay the issue and publication fees, and then the United States Patent Office grants you the patent. If the claims of your patent application are not deemed to be patentable during the examination process, you can either abandon your patent application or appeal the decision of the patent examiner not to grant your claims first to the Patent Trial and Appeal Board, and you could conceivably go all the way up to the United States Supreme Court. Here's a question I often get asked: are all inventions patentable? And here's the simplest answer you'll ever get in this hangout. The answer is no. In order to be patentable, an invention has to be new, and what I'm going over right now are the criteria for patentability. So one is new or novelty. Some of you may have heard that term. Utility, right? So for utility patent, it must be useful. It should serve a useful purpose. It must work. So you can't patent something that clearly doesn't work, like the perpetual motion machine. And it should be not obvious or non-obvious. And the standard non-obviousness is, would it be non-obvious to a person with ordinary skill in that area? Ordinary skill in the art, you may have heard this term. It's important to remember that abstract ideas and mere discoveries are never patentable, and something that the Supreme Court has reiterated in several recent cases. And speaking of the Supreme Court, the law is ever-changing. So it's important to realize that what the scope of patentability does change. Okay, so we've looked at how to obtain a patent. How does one get trade secret protection? Just as a reminder, trade secrets protect confidential information that's better not disclosed. So, and also in particular, inventions that are difficult to reverse engineer. So therefore, you wouldn't want to disclose in the first place. So not surprisingly, no registration or recordation is required. And not surprisingly, again, the less people that know and have access to this confidential information, the better. So you don't have to register it, you don't have to record it. But what trade secret protection does require is that you use reasonable efforts to protect the competitive confidential information. And unfortunately, there aren't any hard and fast rules as to what constitutes reasonable effort. It does depend on the nature of the invention, and there are court cases that provide some guidance on what reasonable efforts are. Certainly, some of these would include how many people have access to the information, what safeguards are in place to protect the information, and so on. For example, I've read that the formula for Coca-Cola is only known to 2 people who never travel at the same time. The original is in a bank vault somewhere, and there are no copies have ever been made. So, as a result, I think that anybody would find that Coca-Cola has effected pretty strong controls over their trade secret, and that has been found in situations where the formula of Coca-Cola has supposedly leaked. In one case, I think to Pepsi, Pepsi has said, we'll just send it back because we know that we could never use it. So they have very strong controls. Now, one risk of keeping something purely a trade secret and having never been disclosed of it or patented it is that a third party could come along and recreate it and disclose it or patent it. This is certainly a possibility, but consider Coca-Cola has kept its trade secret for over 125 years, and it's built a multi-billion-dollar business upon that trade secret. So, and this is, it's not like there aren't other colas in the market. It's a lot of competition. We just mentioned one, Pepsi, but still they managed to maintain their company based on this trade secret. So under the right circumstances, trade secret protection can be very robust. So something for all innovators to consider. So if I can disclose my invention and protect it by patents, or not disclose it and protect it by trade secrets, why do I need to use and register a trademark? Let's start with use first. Using a trademark allows consumers to easily find your product and distinguish your product from your competitor's product. And you can use the TM symbol upon actual use of a trademark. So if you have a product that you're selling that has your mark on it, then you could indicate it with the TM symbol. So at this point you're wondering, well, okay, I can get trademark rights for merely using my trademark on products that I sell. Why do I need to go through the hassle and the cost of actually registering my trademarks at the United States Patent and Trademark Office? Well, you do have benefits of registration. For one, the United States Patent and Trademark Office Trademark Register provides notice to the world as to that you have rights in a particular trademark. The registering a trademark also gives you rights prior to actual use. And I want to contrast that with the fact that you can only get trademark rights upon actual use of your trademark on a product. So if you register your trademark, you can actually get some rights prior to actually using your trademark. So you have an unregistered trademark in which you get actual use from so trademark rights for actual use, a registered trademark where you can get rights prior to actual use. You can only use a circle or symbol when your trademark is registered, and this long and complicated thing, a bullet point at the end, essentially says that if you've registered your trademark for 5 years, it is much more difficult for somebody else to come in and cancel your trademark. So that's yet another benefit for registering your trademark at the Patent and Trademark Office. Okay, so we've seen how we can get a U.S. patent. Let's look at how we can obtain a U.S. trademark. So hopefully by now I've convinced you that a U.S. trademark is worth getting. So how do we do that? First thing we do is we have to pick a mark for a specific good or service. Then we will file a trademark application at the USPTO. A trademark examiner will examine your proposed trademark, and again, you have input in the trademark examination process. There's a slight difference from patents. If it's found trademarkable during examination, the trademark office will not immediately grant it. They first publish it for opposition from third parties. And the goal here is to see if anybody else wishes to oppose your mark. If it's not opposed, then the trademark office will issue you a trademark registration certificate. And the opposition period is 30 days from the publication of the trademark. So if that passes, nobody's opposed your mark, off you go. If, on the other hand, your chosen mark is not found trademarkable during examination, or somebody has stepped in, a third party has stepped in to oppose your trademark, then you can either abandon the application that's your mark, or appeal, and in this case you would initially appeal to the Trademark Trial and Appeal Board, which is the counterpart to the Patent Trial and Appeal Board. And eventually, I guess you could go all the way up to the Supreme Court. Finally, let's look at copyrights. In many ways, this is the simplest form of IP rights protection. And it's important to note that a creator of any work automatically gets copyright to the work as soon as it's transcribed onto a tangible medium. So this presentation, because I've transcribed it onto the computer hard drive or a disk, is automatically copyrighted. So you don't have to do anything more. That's it. But I still would recommend that you register your copyright at the United States Copyright Office. Just like trademarks, you don't have to, but you really should consider it, because registration gives you several benefits, and here are some of them. Once again, like trademarks, is a public record of your right. You can be eligible for statutory damages, and there's evidence of you get evidence of copyright registration if you do it right. Now, once again, we've talked about software in the context of patent protection and trade secret protection. You can also copyright software, and a lot of software is copyrighted. Okay, so how does one obtain copyright registration? Well, the first thing you do is that you fill out an application and you deposit a copy of your work at the United States Copyright Office. The website is very straightforward. There's a review of your work for copyrightability at the U.S. Copyright Office. And if it's copyrightable, you get a copyright registration certificate. If it's not, you can either abandon the registration or appeal the decision. Okay, so we've looked at a brief overview of the various ways in which you can register your patents, trademarks, and copyrights, and the examination process for the patents and trademarks. And before we move on to the next topic, which is building portfolios, once again, I'll pause and turn it over to Chris and see if we have any questions that have come in since our last break.
Excellent. Thank you, Gautam. So again, I want to remind people that you can send us your questions by email at nhlbi_sbir@mail.nih.gov, or you can simply tweet them out using the hashtag SBIRchat, or direct message us at NHLBI_SBIR. That being said, we do have a couple of questions that have come in. And one of the questions that's come in is, how can I use trade secrets to protect my product if I have to disclose the composition of the product to regulatory agencies and end users?
Okay, that's a good question, actually, and it's often been asked. So, yes, it is true that you have to disclose the actual composition to the FDA, then you cannot protect that aspect of it by trade secret. But you could protect the manufacturing process, the formulation, filling process, I suppose, of your invention. So it is true that once you disclose it, you cannot protect it as a trade secret. But there are other aspects of the invention that you may well be able to protect through trade secret, just not the formulation in this particular instance.
Okay. And then another question that has come in is, how long does it take to get through the patent process?
Okay, another great question, one that's often asked, along with cost. And sadly, the answer is it varies, but in general, I would say that for the average patent application, you can expect between 2 to 5 years. So after filing. So you file it, it gets published after 18 months. It doesn't really hit an examiner's desk until between 18 months and 2 years. And then between 2 and 5 years, you're going through the application process, the back and forth that we talked about, which you have input in the process, until you finally get the patent issued. Or abandoned, as the case may be.
And a follow-on question from the same audience member is, do I need to hire a lawyer to do all the work?
You don't, though we strongly recommend you do. The problem is that the process is complicated, and there's a lot of jargon, legal jargon, technical jargon. So you, as the applicant or as the inventor, are not required to use an attorney to prosecute your patent application and deal with the patent office. And in fact, you do see inventors that act pro se, as we call them, by themselves, and can be quite successful. But if your invention is a bit complicated, and to understand what the patent office is saying when you get communication from them, it is very helpful to have somebody to help you decipher that and understand what it is they're asking for and what you need to provide. So again, I'd like to use this opportunity to re-emphasize that the patent office is not your enemy here, and does want to help you get a valid, enforceable patent out of the process.
Okay, and we have one more question that's currently pending before we return to the regularly scheduled programming, and that question is, as an SBIR awardee, what rights does the NIH have to my intellectual property?
Okay, well, so I'll go over that very briefly, but essentially the NIH has what can best be described as march-in rights, that they do have the ability to you can think of it as they have a paid-up license. So they have a license to your invention that they can use if need be. But the NIH has never exercised this right. I know a lot of people are really concerned that the government is going to march in and take the invention and market it themselves and sell the product. And the NIH, as far as I know, no government agency has ever done that. It's just that if NIH money has been used to fund the development of an invention that has been patented, then the NIH has the right to license that invention without any further cost to it, because it already paid for it. And really, as I said, it's been never used, and the only reason that one could possibly think of the government marching in and taking over your invention is there's some kind of catastrophic national security issue or national health issue, and that somehow the government believes that you as the patentee are not able to or unwilling to license your invention, and it's killing a lot of people. I mean, a pretty obscure set of circumstances where it could happen, but just to protect itself, it does have the right to do that. But as I said, as far as I know, no agency has ever marched in, grabbed a patentee's invention, and licensed it, and therefore competed with the patent owner.
Okay, well, wonderful. Thank you. We don't have any more questions at this point, though I do want to remind our audience that you can send us questions either by email or over Twitter during Dr. Prakash's continued talk. Thank you.
Great. Thank you, Chris. Okay. These are some excellent questions. Thank you for them. And thank you for actively participating. The presentation is always made more robust when we have audience participation. So before we file and build portfolios of patents, and I think many of you who have spoken to investors might ask, well, what is your portfolio of patents? It's important to realize that before you can get any patents, and file patent applications, you should make sure that you do not disclose your invention. So in other words, public disclosure is bad because it's almost always a bar to obtaining patent protection. So here's some examples of public disclosure that most of you probably have thought of. Publications, obviously, if you have a scientific publication that you put out before you filed your patent application, that's a public disclosure. If you've spoken at a conference, and remember, this includes the abstracts and the posters you've presented. So those would also count as public disclosures, and not surprisingly, anything you post on the web is public disclosure. Some of you may have heard this term, a provisional patent application. What is it? Well, it is a relatively quick and inexpensive way to file for patent protection before public disclosure. It's important to note that a provisional patent application is never published and it's never examined. So that's important because I've heard, and actually I've seen written, oftentimes people say something like, well, I have a provisional patent. But what they really mean is that I have filed a provisional patent application. So a provisional patent application will never issue as it is as a patent. And there's no such thing as a provisional patent. So while provisional patent applications are relatively quick and cheap to file, there are several things that you really do need to consider. The first thing is that you only have a year once you file your provisional patent application to take some further action. And you want to do that because only then will you retain the priority of your filing. And it's also important to note that you need to put enough in your provisional patent application to support any later filed, what we call non-provisional utility patent applications or international patent applications. So while it might be quick, it may not end up being that quick and cheap, because really the best advice that I can give you is that you should consider drafting a provisional patent application with the same effort that you would put into a non-provisional patent application. So you should try and include figures, you should try and include claims, and you should not merely take your conference abstract or presentation slides, put a cover sheet on it, call a provisional application, and file it at the United States Patent and Trademark Office. You can do that, and I've seen a lot of provisional patent applications that look like that, but the reality is that that could get you into a false sense of security because you don't end up having protection back to that date because you haven't described your invention very well. So I mentioned that the provisional patent application expires a year after it's filed. What can you do in that year? Well, the first thing is you don't have to wait till the year is up. You could do what we're going to describe in the course of that year, anytime. So if you consider step 0 as a step of having filed a provisional patent application at the patent office, obviously you could do nothing and take no action, and in that case, the provisional patent application automatically gets abandoned within a year after it's been filed. And I want to reemphasize that a provisional patent application is never published and it's never examined. So if you want the provisional patent application examined, one option is that you can file a non-provisional patent application at the PTO that claims priority back to the previously filed provisional patent application. Now, we just did talk about how that these applications, non-provisional patent applications, are examined and that you have by the patent office and you have input in that process. And we've seen the rest of the story before. If the claims in the non-provisional patent application are found patentable during examination, the patent office will eventually grant the patent. And if they're not, the claims are not found patentable, then the applicant can either abandon the application or appeal. So there are two options at this point. You can do nothing. Provisional patent application goes abandoned automatically. You can file a non-provisional patent application, which gets examined and either eventually issued or gets abandoned. And then the last option is that you could file one or more international patent applications that claim priority back to the provisional patent application. So now that we know how to file, and how to file, what to file, when to file, we can consider protecting aspects other than the core invention. And this is what we call a patent portfolio. And it is multiple patents. It could be utility and design, and others, there's things called plant patents, on different aspects of the invention. Here are some of them. Other commercially exploitable features, potential new uses. Of course, patents in other countries are an important part of a robust patent portfolio in this increasingly international world. So you would want to consider filing for patent protection internationally. And you can do that in two ways. The first way is you can directly file a patent application in very specific countries that you know that you want to file in within a year of your first US patent filing. So if you file the provisional first, it's within that year. If you've gone straight to the non-provisional, then it's within a year of filing the non-provisional. And then you would prosecute those patents in those specific countries. And some of you may have heard of something called the PCT, or the Patent Cooperation Treaty. And this is an international patent application. You can file one or more of those, again, within the first year of your first filing, within a year of your first filing. So once again, if your first filing is a provisional, you file an international application, a PCT application within the year of that. If your first filing is a non-provisional, then you file within a year of that. And then that international application is, you can think of it somewhat as a provisional. It's not provisional, it's never issued. It gets published, and you then use that to enter very specific countries and obtain country-specific patents in those countries. Now, why would you want to do that? File a PCT versus going directly into those countries that you're interested in. Well, in the beginning, you may not know what countries you're interested in, and the PCT gives you additional time, and it allows you to defer costs of filing those specific countries. So, if you file a provisional application, patent application, and within a year you may not be ready. You may not know what countries you're in, you may not have the money. So a PCT application is a good way to go to defer costs and decide where you want, what countries that you're really interested in. Okay, so talked a lot about getting international patent protection. Well, why would I want to do that? I know, and I have heard questions of people saying, well, I don't ever see myself exporting. I'm a small company. Why do I need all this stuff? Well, here are some reasons. You could end up exporting and to other countries. So that's one thing that you want to look at is where you see yourself either exporting those countries, or maybe you're interested in making products in the pieces of your products or the whole product in those countries, where you see your market growing and where you see competition. Other countries have different patent types with different standards of patentability. So they have cheaper patents. Germany is being a good example. And where are the what countries the patents are enforceable in? And frankly, if one of your goals is exit by acquisition by a larger company or a partner, commercial partner, they will want to file and be able to file in other countries because they have businesses in those countries. So coming to them with merely a US patent is not a very good selling point for you. So at least having an international patent application filed gives an acquirer the option of filing and obtaining patents in multiple countries. It's important to note that strict timelines. We talked about the 1-year timeline for obtaining, for filing an international patent application, and even entering countries. So you want to be aware of those. They differ, and it would take too long for me to explain which ones and what countries. But it's important to note that there are strict timelines. And while it's considered difficult to obtain patent protection in the US when you've publicly disclosed prior to filing, in the rest of the world, it's almost impossible. So you're out of luck for the most part if you have disclosed anywhere before filing your application. So it's important to remember that patents are territorial. And this question I have been asked, where the question goes something like this. Well, I have just a US patent. I think that somebody is infringing my US patent in China. Can I do something about that? The answer is no. Unless you have, if you only have a US patent, there's nothing you can do about it. What you need to enforce your rights in China are the corresponding Chinese patent. Talking about infringement, in the US at least, infringement occurs, as we discussed, where an unauthorized party has made, sold, offered to sell, or imported the invention into the US. Other countries have different criteria. I just wanted to remind you of those. Again, I won't go over what those are. And you can stay out of trouble, or at least attempt to stay out of trouble, by getting prior art searches, freedom to operate, patentability, non-infringement opinions. Some of you may have heard of these terms. So those are the ones that you can get from patent attorneys and other professional patent searchers. Let's talk about some trademark portfolio considerations. They're somewhat similar. You want to register your trademarks in countries where you're selling or planning to sell. I want to just alert you to something called the Madrid Protocol, through which you can obtain international trademark rights, and which you can think of as the trademark equivalent of the PCT, or Patent Cooperation Treaty. Another consideration is to register trademarks in countries merely to prevent others from registering the same mark in bad faith. Remember, a trademark is a source identifier, and you don't want consumers thinking that shoddy or counterfeit goods come from you in other countries. So some companies file, you'll see layers of trademarks. So some companies will file a house mark as an umbrella over several product marks. An example I'm sure all of you know of is the house mark Apple, which is probably one of the most valuable trademarks out there, and individual product marks like iPhone, iTunes, and so on. It's interesting, I just read that the recently released Apple Watch is not called the iWatch because finally another company has obtained that trademark. So has already obtained the trademark, so Apple is calling it the Apple Watch. So it's important to have maybe thought about that before they while they're developing the product. And unlike patent infringement, trademark infringement occurs when there's confusion as to where the goods or services came from. And once again, we're going back to the trademark serve as a source identifier. So to recap, we've looked at the sleep apnea device. We looked at utility patents, and it's called the utility patents, how it operates, and what its components are. We looked at the design patent, protecting how the face mask assembly, which is a piece of the mask, looks. We looked at several trademarks that are protected by, one of them being simplest, which is shown there. And we also looked at copyright protection for the CPAP instruction booklet. And then, while not specifically related to the CPAP device, we examined trade secret and trade dress. This table, just to provide you a quick comparison of the IP rights that we went over, I'm not going to go into any great detail, but just to note that each IP right has its pluses and minuses. And a good strategy is to recognize what the right is, what the right provides, what it brings to the table, and to use them accordingly. And really a very strong intellectual property strategy is to use different rights for different things. So some concluding thoughts. IP rights are territorial. We mentioned this a couple of times. So the most well-known one is in the biomedical area is patents. Talked about trade secrets that could be useful, and you have trademark rights that we talked about also, and you can think of them in addition to source identifiers also representing the trademark owner's goodwill and reputation for quality and reliability. So we talked about not wanting shoddy or counterfeit goods to be associated with you no more. And with copyright, I just want to tell you that there's something called the Berne Convention, which you can think of as the international copyright counterpart to the PCT for patents and the Madrid Protocol for trademarks. So you can get international copyright protection as well. And again, for the last time, you must have rights in a country to be able to enforce in that country. In other words, there's no such thing as an international patent. There is an international patent application, but no such thing as an international patent. There's no international trademark either, meaning there's nothing that you can just buy one trademark and enforce in all the various countries. You have to get them in individual countries to be able to enforce them in those countries. So finally, here's some hopefully potentially useful resources. We talked about some FAQs, overview of the examination and registration processes, some good tutorials actually from the Patent Office and the Copyright Office, which is part of the Library of Congress, the PTO and Copyright Office Assistance Centers, and some forums that might be helpful to you. And this is how you contact us. Chris already mentioned a few of these. And finally, Chris, I'll turn it over to you for any concluding thoughts, any questions that may have come in for the time we have left.
Excellent. Well, thank you, Gautam. That's been a fabulous presentation, and it's generated quite a bit of interest from our audience. So I'm just going to start hitting you with some questions that have come in. One question is, can you sort of discuss how a principal investigator should or should not share intellectual property with co-investigators on a grant or project? Who actually makes these decisions? Is it the PI? Is it a tech transfer office? These sorts of who makes those decisions? And in in a similar vein, we have a question about sharing experimental results during department-wide lab meetings, where several labs may be coming together to discuss progress, and whether that would count as public disclosure.
So, with respect to your first question, if you're a PI at a research institution, you really should always involve the tech transfer office. They're not the ones making that decision. They will follow the rules or the guidelines with respect to public disclosure. But in the case of co-PIs, they're usually co-inventors. So that is generally not an issue. With respect to a lab meeting, an open lab meeting, yeah, it's conceivable that that could be considered a public disclosure, depending on who's there, and if the people if they're co-inventors, it's not a problem. And also depends on what the experimental data. If it's just purely, listen, this is the way I run this assay, it's probably fine. But in general, if you've got an invention that you actually think is commercializable or patentable, it's always better to err on the safe side, to have non-disclosure agreements if you really need to get that far. But involve your tech transfer office, indicate to them what it is that you're developing. They can help you early on along the way and sort of give you a good idea of what you should and shouldn't be doing in order to protect your rights as effectively as possible.
Okay, great. Thank you very much. And another question that's come in. Do I need to file my patent before I submit my SBIR application? And in a related vein, does my SBIR application count as a public disclosure?
The answer to both is no. So you do not have to file your patent application before you file the SBIR application. An SBIR application is not considered a public disclosure. However, once again, erring on the side of caution, you either want to file your SBIR application concurrent with your patent application, or even better, maybe file your patent application prior to filing your SBIR application. I know people who get it all ready, will file the patent application the day before, and then the next day is the deadline to file the SBIR application, and they submit that to the NIH. So that way you're protected. But really, the answer is no to both, that it's not considered a public disclosure, and you don't need to, but you probably should file your patent application before you file the SBIR application.
Okay, great. Thank you very much. Another question that's come in is, if a patent holder has not paid their maintenance fees, can I assume their IP?
So, I don't know about assuming their IP, but the patent owner does have a grace period to file their maintenance fees. So, for those of you who may not be aware, at 3.5, 7.5, and 11.5 years after the issuance of your patent, you need to pay the patent office fees to maintain that patent. So when I say 3.5, really there's a time window of 6 months, I believe, during which you need to pay that fee. So the first thing is you need to make sure that even though the time has passed, the window hasn't closed, because the window is around that 3.5-year time frame, or 7.5, 11.5. And the second thing is, I have seen situations where you can get a patent owner can pay the fee later and reclaim patent protection. But let's assume that years have passed and the patent owner has not paid their maintenance fee, any one of them, then the patent is dedicated to the public, and it's part of the public, and you can use it. I'm not sure you acquire it, but you could use it. It's now part of the public domain.
Okay, well, thank you very much. Unfortunately, that's all the time that we have for questions today, and we have, I believe, covered all of the questions that have come in. So at this point, what I would like to do is I would like to see my slide load properly. But as that doesn't seem to be happening, I'm going to try stopping and resharing my screen, because we have some very exciting things going on here in our office, one of which is that we'd like to get your feedback on today's presentation. So if you'll give me just one moment, I'm trying to pull up this presentation again, and it's not going to work for me. Hopefully it will. Nope. Okay. On that note then, there is a feedback form where we would appreciate hearing from you, and I'm going to look that link up as I speak, and I'll just talk it out loud. And it is a bit.ly link, so it's https:// bit.ly, pardon me, bit.ly 0415 capital H little ANGOUT capital F little EEDBACK, so 0415 Hangout feedback, all one word with two capitals in there. And pardon me, if you would be so kind as to go to that link and provide us with some feedback on today's presentation. We would, at the end of that form, there is a place where you can submit your email address if you're interested in receiving the presentation of Dr. Gautam Prakash and all of that lovely information that he just shared on his PowerPoint presentation. We'll be happy to get that out to you with a minimum 2-day turnaround time. And finally, to close out our presentation today, I would like to remind everyone that our Hangouts are turning into a bit of a monthly event. Our next event will be Connecting with Your Customer and will occur on the second, I believe, Tuesday in May. You can sign up for our listserv, which is in Dr. Prakash's deck, and receive information and update about that. And then in June, we will have another intellectual property focused Hangout, Making Your Mark, Understanding Trademarks and Their Use to Protect Your Intellectual Property, and that will again be presented by Dr. Prakash. The NHLBI Small Biz Hangout series has been developed and is executed through the NHLBI Office of Translational Alliances and Coordination. If you are developing a biomedical technology that falls within the cardiovascular, blood, pulmonary, or sleep disorder and disease space, please reach out to our office for any additional questions or assistance that you might have. If you're developing a biomedical technology in some other area of NIH's space, please reach out to the NIH Office of the Director, SBIR Program Contact, who is appropriate, to help refer you to the institute or center that would oversee your biomedical technology development. And with that, we thank you so much for your attendance and participation in today's Hangout, and we hope that you have enjoyed today's event. Check out our archived events on the NHLBI YouTube channel, and tune in again next month. Thanks so much.
Thank you.